Safeguarding consumers of goods and services and the public against unfair practices in the marketplace is very important to guaranteeing consumer protection. The Vice Chairman and Chief Executive Officer of the Competition and Consumer Protection Commission, Babatunde Irukera, has said that players in the power sector, manufacturing sector and digital space may experience stricter regulations in the interest of consumers in 2023. According to him, to this end, the agency has started unbundling more of its regulatory tools to create room for penalties in the months ahead. Lately, consumers have lamented on the rate of failed transactions, especially during the festive period. But with the Central Bank of Nigeria commencing full implementation of its policy on cashless economy, more consumers will move to digital channels and the ability to meet face-to-face will diminish. This not only changes the dynamics of customer experiences and engagement, but also impacts the ability to create an in-person selling opportunity. Joining us on the show this morning to discuss ways to improve consumer experience and what his agency is doing to ensure customer safety is Babatunde Irukera, Executive Vice Chairman and Chief Executive Officer of the Competition and Consumer Protection Commission. Welcome to the morning show.
All right, pleasure to have you, sir.
Good morning, thank you.
Pleasure to have you, sir, and Happy New Year. Good to see you again after a long while. Pleasure to talk to you again. Real quickly,
Same to you, and thank you.
Let's just go straight to it. A lot is happening as regards, the competition space and quality of service for consumers out there. I would like to get some updates at first on those loan apps. The last time we spoke extensively about those loan apps, and you said you were doing everything to nip them in the bud. We'll get some updates as regards then we'll move on from there.
Excellent, thank you. About this time last year, it was literally a runaway train. Almost at least everybody knew one person or the other who had been defamed in one way or the other by one loan application or the other. By March of last year, it was literally an epidemic. And we started enforcement in March of last year. Towards the end of 2021, the FCCPC led an interagency joint task force to develop a strategy to address that. And between March and August of last year, we were quite heavy on investigations, enforcement, tracking, and enforcing some level of change. As at today, I'm grateful to say that there's been significant reduction in the defamatory messages and the loan compoundment. And that's in part on account of the enforcement work by the Joint Task Force made up of the multiple agencies, and also the interim regulatory framework that was released and instituted through FCCPC by the Joint Task Force, and the cooperation and collaboration of partners such as Google through Play Store, and the telephone companies and other payment gateways like Monify, Flutterwave, Paystack, OPay. We've been able to literally make business very difficult and sometimes even impossible for the loan apps if they don't comply with the framework. The framework requires some transparency, visibility, and policies to protect consumers, evidence that they comply with the Nigerian Data Protection Regulation, and a bunch of other things that safeguard consumer interest and prohibits them downloading information from subscriber telephones that they haven't consented to. And that has certainly modified the space. Digital lending is still going on. In this process, we've discovered that some companies were ethical and they are the better for enforcement work. And some of the businesses that could possibly change their ways have been through the regulatory process and the registration process, and Google has put them back on Play Store, and we've seen far less complaints about the conduct of the digital lenders. We continue to scrutinize and monitor what's going on. There's still pockets of complaints about these violations, by mostly those who are underground. We continue to do the work we can to fish them out and address their continuing violations of the law. But it's fair to say that we've got this situation under control, even though it's not eradicated.
Well, good to be speaking with you this morning, Mr. Irukera, because I believe that many Nigerians would be interested in this particular conversation because of what we deal with when it comes to consumer experience, customer service, customer protection. Let's go to the banking sector, particularly because the CBN is very adamant about its push for a cashless society. In order for this to happen, there must be structures in place to ensure that consumers are protected, particularly if we're moving, as you just discussed, to the digital space. A major complaint for a number of consumers is that we keep getting failed transactions. And I use that term "we" very deliberately because I'm currently facing, discussing with my bank over a failed transaction that happened in December. The long time for it to be resolved, how bureaucratic the process is. Sometimes consumers don't even know the channels. I know the Central Bank of Nigeria has a CPD, that's Consumer Protection Department, and they're quite active, but people are not quite aware of this. What efforts would the Commission make to, number one, educating Nigerians on their rights, the channels available to them to make complaints, and as you've mentioned, the penalties that these organizations face if they do not comply?
Thank you. The financial institutions sector is quite tricky. Immediately, CPC, as it was before it became the FCCPC, was continuing to address complaints from the banking sector. And at some point, that was the banking was the largest volume of complaints we received until it became power. And even up till now, it's still the second largest. But sometime, I want to say in 2020, a new law came, which was the Bank and Other Financial Institutions Act. And what it did was to exclude the Federal Competition and Consumer Protection Act from the banking industry, meaning the oversight work that the FCCPC does with resolving complaints in the financial institutions or with respect to financial institutions became limited. And so essentially the real statutory platform for resolving banking complaints is not the central bank exclusively. However, because banking constitutes the second largest complaints we receive, what we have done at the FCCPC is to continue to do the work in the banking sector based on an understanding that withdrawing that channel would absolutely be chaotic. And so we're struggling with having the statutory tools to deal in the banking sector as we used to. And one of the things that is the result of this is that we don't have the visibility that we would have had to be able to contribute to policy and execution of policy in a way that would have truly and fully captured what we know based on our experience in dealing with the banking customers and what we understand the landscape of the industry to be. Be that as it may, we continue to resolve complaints on a daily basis, and we receive hundreds of them literally weekly. But what we can do, the limit of what the FCCPC can do based on the limitations of the statutory instruments is to at least get the banks to address what the issue is. With respect to the question of penalties, the kind of statutory power to penalize inappropriate conduct is still questionable.
All right. Always seeing you, it's always a chance to discuss a potpourri of issues. I know this also extends into the medical and healthcare sector. I know the FCCPC had been back and forth with regards fighting for the rights of Nigerians that have died, because of some, debatable activities in the medical sector. And I know last year and the year before last was a long one for you as regards that. Can you keep us updated as regards, all of that without, striking any legal red flags as regards, how that case went? We all remember the case of the chef that died after a procedure of Blessed Mary Goma.
That's a good question. And I suppose with the same principle, you've got composite competition and consumer protection regulator in the FCCPC. We do not regulate any particular, we're not a sector regulator. But we continue to struggle with enforcing the broadest consumer protection regulatory framework across all the different sectors and industry. Most sectors, whether the players or the regulators, are quite concerned about the role of a composite consumer protection regulator. And understandably so. The FCCPC has adopted what might be considered a radical and certainly very disruptive approach to enforcing the rights of consumers. And that became necessary because we're coming from a history of very poor responsiveness and sensitivity to consumer issues and customer service. And so that disruptiveness and that potentially radical approach is something that would certainly create discomfort amongst businesses and some of their regulators. And so in the healthcare sector, professionals, especially doctors, have found the role of the of the FCCPC very uncomfortable. And in part, the regulator for the conduct and actions of doctors also shares the discomfort of the NMA and the medical professionals. We're working through that both by engagement, by consultation, and certainly also by the hard-nosed work of enforcement and even conflict management. And so that, in some sense, has slowed down some of the best enforcement strategies, but that's okay. The reality of it is that part of our work is to catalyze other regulatory authorities. And I'm personally very proud that the Medical and Dental Council in the past year has had more cases or handled more cases than it has in many, many years put together prior to that. Recently, someone was a very senior medical professional, was sharing with me that some of the very much older professionals in medicine came together and literally have jointly expressed great dissatisfaction as what they consider a rising rate of complaint against the professionalism and the outcomes that are coming out of the medical space. And those are, catalyzing that kind of action is actually a win for the FCCPC and one that we hold very dearly. The medical sector is one that's extremely sensitive on both sides. We certainly can go in there and act like you can disrupt how things are set up to work, but without question, the question of how patients are treated, patient care, has both a professional liability aspect and then a general consumer protection aspect. And holding people accountable to that consumer protection aspect is something we're sworn to without apologies. And so while we recognize, respect the sensitivities and even the displeasure or discomfort of the professionals in the industry, we have absolutely no apologies for holding them accountable to what we believe the law establishes. And that has worked to some extent. For instance, I know the case you're talking about is the Premier Hospital case. And even though it seemed like our own investigation into that was throttled and slowed down because of this dispute and the intervention, we carried our role onto the coroner's inquest. The Coroner Law of Lagos State allows a coroner's inquest to be instituted. And so the FCCPC went into the coroner's inquest as an interested party. And were able to participate extensively, asking all the questions, making all the points that we would have made in the course of our own investigation. And we're anxiously awaiting the outcome of a coroner's inquest. But it suffices to say that for all who monitored and followed the coroner's inquest, there are already lessons learned. Someone was saying to me recently that an emergency was taken into a hospital, and the feedback from the hospital was, let's be very careful, because this is a very publicly sensitive emergency, and we can be sure that the FCCPC is probably going to make a statement about this and scrutinize even our own conduct. And so we're catalyzing action both on the regulatory side and on the operational side. And the role of a regulator is actually just to improve the space. We don't win because of the number of penalties we award or the number of enforcements we do. We win when the entire space is better. And with the better, when people learn to comply with the law or improve standards simply because they do not want to be engaged in the regulatory system. And so there are quite some good wins, in my opinion.
All right, well, thanks. From a regulatory perspective, I know that you're currently working on investigations around the power sector, particularly the alternative power sector, where they've been, following your investigations, found price fixing for generators. What you said around strengthening the system so that we don't even have incidences like this happen. I'd like to know what, from the outcome of your investigations, what your agency would be doing to further strengthen the protection of consumers, especially in the power sector, for generators. And then I'd like you to speak to flights. This is an area that a number of Nigerians have an issue around: flight delays, rights of passengers. Beyond even asking for compensation, it's regulating that sector to ensure that they're protecting the rights of consumers. It would be good for you to share your views on these.
Thank you. So there are two issues there. There's aviation and then there's power, alternative power. And the principle or the philosophy that is at the back of our intervention in power is fundamentally the cost of power is perhaps the largest cost to domestic lives, certainly industrial life. And because it's going to take time to develop both generation, transmission, and distribution capacity, that's hard infrastructure that running its own course and having its own trouble. The least that society should experience is that they're not, the candle isn't burnt from those ends, and they're not shortchanged even with respect to the cost of providing the alternative power, which typically is now renewable energy, but primarily generators. And so we got credible intelligence that in the generator sector, there were a few things that are going wrong. Number one, in order to address the generation, transmission, and distribution deficit, one of the things the government has done is to relax certain rules with getting your own alternative power. One of them is reducing or even eliminating duty with respect to CKDs, which are completely knocked down parts to build a generator. And so most generator importers bring in these completely knocked down parts and then assemble. That does two things. It makes it, the lack of duty makes it more affordable for the consumers. And then also, it also promotes local industry in the sense that at least it brings a value adding process to be done domestically, which is the assembling. But the spare parts continue to attract duty. And what we saw was that there were some businesses that would import these engines, a few engines in a container that will be dominated by spare parts and portray that as completely knocked down parts, thereby paying far less duty than they should. And we engaged the customs service and we were able to get some data about some of the containers that had moved, the container movement, and we got some information. We also discovered that there was some level of coordination, maybe not at the very top, but at the sales level, some of the companies were talking with themselves and agreeing by signaling on how the prices move. Now, you must realize that the best price for anything is a price that is negotiated in a free market. And that free market is one that is not distorted. A free market means that all the competitors come into that place and compete fiercely for the custom of the customers. But to the extent that they can coordinate or in any way, shape, or form attempt to, either by express conversation or by signaling to each other, coordinate their pricing, the market is distorted. And it's not a fair competitive market anymore. And so with all that information that we had, we presented that to a judge of the Federal High Court, and when the judge was convinced, the judge issued a search warrant and order for us to execute. And that's what we did. We executed a search warrant simultaneously on multiple operators in the industry at the end of last year. Usually an investigation of this nature takes quite a while, because first you now have to start, slicing the information that you've got. We've gotten several terabytes of information that's downloaded from their computers, their emails, their telephones. And so we're analyzing that information now. Some of what we've seen confirm the allegations, but we'll continue the work.
Okay. All right, we'd like to say a very big thank you. And definitely maybe when next you're here, we'll talk about the flights. Goodness me, there's something else. But thank you so much for your time, and have a very good year.